Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. From challenging the ICC's jurisdiction to pushing for his interim release, the camp of former President Rodrigo Duterte isn't backing down on efforts to question his continued detention in The Hague. In their latest move, the defense team requested for an urgent status conference just ahead of the court's recess. What does this mean and what are the possible implications? Let's get on point with former ICC judge and UP College of Law Professor Emeritus Raul Pangalangan. Judge, good to see you again.
Wonderful to be here. Thank you for inviting me.
Finally, in person. Yes. The last time I had you, I was still with CNN.
Indeed.
And you were on Zoom back then. Let's begin with this, Judge. A few days ago, it was the defense team, rather, that requested the International Criminal Court for what is called an urgent status conference prior to its July 25 summer recess. So now we know that by July 25, they will be on a summer recess.
That's correct.
What is an urgent status conference? What does it mean? What does it entail?
Under the rules, the status conference, Pinky, is just it is almost a routine procedure. It's for housekeeping matters. So basically, the court assigns. It doesn't even have to be the entire pretrial chamber of 3 judges. They just designate just one member of the chamber to meet with counsel, and to discuss the practical planning of the forthcoming confirmation of charges hearing in September. So it can deal with the scheduling of witnesses, the sequence of the procedure that they will follow. They have, I think, 3-4 days of hearings to do that, to allocate the time. So if you look just at the rules, the hearing that is being requested is humdrum and routine. They say it is urgent because, the only copy of the request is redacted. So they blocked off many portions. But if you read between the lines, basically they were claiming that things were not moving fast enough because they don't get responses fast enough from the prosecution. And so they would like this hearing to get things moving so that they're fully prepared for September.
So the understanding is it an urgent status conference because they will be on recess by July 25, which is basically a week from now?
Yes, I guess they would like to schedule that soon enough so that whatever is decided during that status conference, they can sort of implement during the...
But is there time? Is there enough time? 1 week? This was filed, I believe, about 2 days ago. So they're asking the court within 9 days to be able to have this conference. In situations in the past when you were there as a judge, what is the likelihood of this happening?
Well, it is possible. It is doable. Of course, exactly as you say, it's rather a short notice because the hearings have to be set up, notices have to be given to the parties. But I think if they did the filing about roughly 9-10 days before the summer recess. I guess they were banking on, they're still hoping that it is possible. So short answer, yes, it's doable, but it's a very tight deadline.
I guess I was asking that, Judge, because I was questioning the urgent motion. If it was very important, well, I'm sure it is. I guess one would assume that it could have been asked at least 2 or 3 weeks prior to the time they actually asked it, which is about 2 days ago.
Well, you're correct. They could have filed it sooner. I can see, I can imagine them saying we waited until now so that for us to get responses.
Whatever documents
yes.
that they wanted.
Yeah, and so we draw the line on this date, and finally we make the request. So, you know, I can imagine some justifications they can make.
Okay.
But they were pushing it.
They want to know if the current timeline of the confirmation of charges is feasible, which is set for September 23. What does that mean? I do understand what it means in English, but
Yeah.
if it's feasible on September 23, ibig ba sabihin nun, is it possible that the September 23 confirmation of charges might not happen?
Well, that is a call of the pretrial chamber. But the chamber has already issued an order setting it for hearing starting September 23. Now, when they say that maybe it's not feasible, what they're basically saying is that the hearing is there to receive the party submissions and their evidence, and that the preparation time is not enough to do that. Well, the prosecution has filed 12 rounds of disclosures of their evidence at this stage. And so if the question is, has the defense been fully advised of the evidence to be used against their client? I think they have. I don't know what they can complain about.
Can you explain that further to us, Judge? What do you mean by the prosecution has already submitted 12 rounds? What are 12 rounds?
Oh, okay. You see, we actually have the same rules in the Philippines, that the prosecution must disclose fully to the other side all its evidence, both the incriminatory and exculpatory evidence. In other words, I can imagine in the Philippines people saying, "Oh, you mean the prosecution will reveal to the defense all their evidence which will be useful for the defense in favor of their client?" And my answer is yes. And that is an obligation which is taken very seriously in the court. In fact, I remember, Pinky, one time when, of course, there has been full disclosure, and then it turns out that a document was disclosed by the prosecution, but there was one missing annex. And you can imagine the courtroom dramatics arising from the missing annex, which was actually an innocuous document, but still, you can imagine the defense counsel.
This happened when you were a judge?
Yes, it's typical in courtrooms because they catch the other side having failed to disclose a piece of evidence. So that is what I meant, that at this stage, the prosecution has already reported to the court that these are the kinds of evidence that they will present.
This is a type of trial, Judge, where the defense will know all the crime obviously that he is being charged with, the witnesses that will appear, and the testimonies that will form part of their disclosure?
That is correct. Although, again, I must emphasize another basic difference between the ICC and what we know here in the Philippines. In the ICC, it's prohibited to rehearse the witnesses. So especially for the prosecution, the first time that they will hear the witness's testimony is when the witness takes the stand in court. Until then, all they have is the interview of the witness during the investigation. And I imagine that interview will already tell them that, well, this is a witness we would like to present in court.
How will the court know that you did not rehearse the potential witness?
It is prohibited. In fact, that was my very first case assignment in the court. It is considered an offense against the administration of justice.
I see.
And in fact, I openly tell people in the Philippines the rule is different. In fact, you have even the judicial affidavit, where the lawyer basically drafts the Q&A for the direct testimony, which really shocks people abroad, I've got to tell you.
To be honest, I'm actually shocked that it's the opposite in the ICC.
Indeed. Yes. Because the approach is, they call it the principle of orality, the principle that the truth of the witness must not be rehearsed.
I need to clarify this, Judge. You're saying that the defense cannot rehearse?
No lawyer, prosecution or defense,
Can
or victims
talk to a
counsel.
witness.
They're
No one.
not supposed to. The witness, there is, we prohibit witness, all we allow is witness familiarization. Someone will brief the witness saying, okay, you're going to sit here on the witness stand, there will be a Q&A, someone will ask you a question, and then you answer. Don't talk until you are asked. And just ask, if you don't know the answer, just say you don't know it, and just testify on what of your own direct and personal.
So there's no rehearsal really whatsoever, because how I understand the courtroom, the formation of the courtroom is you have the defense, you have the prosecution, and you have the other part, the lawyer for the victims.
For the victims, that is correct. Now, they all have their turn.
Yes.
To present witnesses and to cross-examine.
And my understanding and what I was told, that the prosecution and the lawyer of the witnesses do not talk. They do not corroborate. They do not speak to each other. Would that be true?
Meaning I'm sorry.
The prosecution
and
the lawyer for the victims? It's almost as if my understanding was they're treated as separate entities.
They are, indeed, they are three different teams. And if you look at the record of the court, in fact, in the past, like in the Philippines, one would assume that the prosecution and the victims' counsels will be like working together.
Right.
But in the past, it has happened in the court that they would disagree with each other. But of course...
Parang hindi sila magkakampi. Pero dito, sa Pilipinas, magkakampi po obviously yung prosecution tsaka yung biktima.
That is correct, yes. And of course, you can imagine all the rhetoric saying that victims' counsel is not a second prosecutorial team, you know, stuff like that, because they're there just to vindicate the victims' interests and concerns. That's the jargon of the Rome Statute. But you know, those are the fundamental differences between the court, the ICC, and the Philippines. If I may point out another, Pinky, for us, we file the charges first, and then we issue the warrant of arrest. And here, the warrant of arrest has been carried out. And the guy is already under detention, and then we are still discussing the charges that he will face.
That's actually been discussed quite a while, quite for some time.
Yeah.
Baliktad kasi sa ICC. Sa ICC, arrest warrant muna, tapos charges. Sa atin, charges muna, tapos arrest warrant.
That is correct. Yes. Although, of course, we have a pretrial chamber in the ICC, which is a judicial a proceeding to review the charges to be filed, something we don't have in the Philippines.
I want to just go back to what was stated in this urgent status conference prior to the July 25 summer recess. You're right. It was saying a lot of things that were redacted, which I was obviously trying to understand.
Yeah.
And I'm sure, I'm hoping you can help us out with some of it. A month has passed. Basically, you were saying, Judge, it's a lot of delay. A month passed from the moment that the defense requested, redacted. So they requested something April 15, 2025, until they were received 16 May. So natanggap po nila 1 month later. The other one, the redacted, underlying redacted, on May 16 was only supplied to the defense July 7, June, July. So that's around 2 months after. Unredacted, obviously that starts with a vowel, requested more than a month ago. Redacted is yet to be redacted, and the redacted more than... So, you know, it's really hard to make sense of these, what could possibly be the delays. All I can think about, Judge, is this. Some of the motions that the defense have filed, from my recollection, there would be 2, which is the issue on jurisdiction and the issue on interim release, because there was another one on the judges that they had filed that was already decided on by the panel of judges for basically saying these 2 judges are not biased. They have not shown any bias. Would you be able to help us? I mean, even if it's
of course,
if it's right to talk about that redacted, what are these? Are these the issue on jurisdiction? Issue on interim release?
Well, exactly as you say, it's guesswork on our part, because it's all we have to read between the lines, and even the lines are missing. Okay. Well, I imagine this is a back and forth on evidence that that they want. Some document. But if you look at the submissions of the prosecution before the pretrial chamber, they're all on the crime of murder, the crime of against humanity of murder. Maybe the defense basically is asking for clarifications on some of the pieces of evidence. Now, your question on whether it might pertain either to the request for interim release or the challenge to jurisdiction, well, okay. Those are basically, I would say at this stage, questions of law. And the redacted stuff, I think, are about, again, I surmise questions of fact. And I imagine also that for the questions of law, they have fully ventilated it. They have had, I think, 2 rounds already of comments and replies. But, well, it is possible that they might want a ruling on these matters before September 23, but again, that's just a possibility.
Still a lot to discuss. The September 23 confirmation of charges. I wanted to get your thoughts on that, Judge, and of course, the issue on jurisdiction and the interim release. But we need to take rather a short break. We'll continue our discussion with former ICC Judge Raul Pangalangan. When we return, stay tuned. This is On Point. Welcome back. Still with us, former ICC Judge and UP College of Law Professor Emeritus Raul Pangalangan. Let's talk about the September 23 confirmation of charges. It was a surprise when the former president showed up online to us last March, if I'm not mistaken, Judge 11, when he was not personally appeared online before the judges.
That is correct, yes.
And then it was a little bit of a surprise for most of us that the next time we were going to see the former president was April, May, June, July, or 6 months after for his confirmation of charges.
Yes.
Medyo nagulat po kami doon.
Yeah.
What happens on September 23? My understanding is going to be 4 days of confirmation of charges.
That is correct.
Why?
Yes.
Why that long, and what happens in the 4 days?
Because the prosecution presents some evidence to basically to convince the pretrial chamber, the 3 judges, that there are reasonable grounds to believe that the crimes charged have been committed. So, in fact, this pretrial chamber was quite careful to say that don't make this a full trial on the merits. This is just a preliminary hearing just to confirm the charges, because the output of the court after this is to release the charges. And then as soon as the charges are confirmed, then they form a trial chamber. We move to the next stage. Tapos na yung pre-trial, we then proceed to the trial. A new set of judges will be assigned to hear the case then.
Judge, so yung pre-trial, yung September 23, 24, 25, 26, are those 4 days enough for them to decide if would that be correct, a full-blown trial shall proceed, or if the case should be dismissed?
Well, if the court set it for trial for hearings just for 4 days, then the court feels that that should be enough, because the evidentiary threshold is very low anyway. Reasonable grounds to believe.
So parang probable cause po sa atin.
Yes, that's right.
Okay.
Although again, the lawyers will nitpick about these terms. But
What
yes,
is it called again? Reasonable?
A reasonable basis to believe.
Basis to believe.
But yes, they will present their evidence. The prosecution, I understand at this stage, has already filed its document containing the charges. In the Philippines, what we call the information. These are the material facts constituting the crime, and the facts that the prosecution must prove beyond a reasonable doubt in order to to convict. And so yes, I think 4 days should be enough. And then if at the end of the 4 days, there are three options for the court. If the court says it's enough, then they confirm the charges, and it becomes then the pretrial is ended and they proceed to trial. If the evidence doesn't support the charges, the court basically throws out the case, and that's the end of it. And the third option is that the court can basically tell the prosecution, go back and give us more evidence, or consider filing another charge. And something which is, I think, implied under the rules, not just filing another charge, but recharacterizing what we call the mode of liability. Was Duterte the mastermind? Was he a direct perpetrator? Because right now the charge is co-perpetrator. Or was he merely, is it merely accessorial liability? When he assured his soldiers, proceed with the killings, you will not be investigated. If investigated, you will not be charged. If you're charged, you won't be acquitted. If you're convicted, you will be pardoned. If you use that mode of liability, that it will be accessorial. So those are the things that can be changed.
Third option. My question is, do they make a decision on the fourth day? Whether, let's say, the options were one of the two, to proceed with trial or to dismiss. Will it be made on 23 and 40, on the 26th, on a Friday, or do they need time?
They need time. Usually, it will take a while.
What is a while? 2 weeks, 1 month, 3 months?
I'd rather not speculate, but they can very well issue it the next week. It's basically the confirmation of a document already filed anyway by the prosecution. But look, as a practical matter, courts have timelines, internal timelines for them to move on these matters. But I don't know if they have made these timelines public.
But can they make a decision on the fourth day?
Theoretically, yes.
Also, they can do that. So it's really up to them.
Yes.
But will we know prior to September 23?
Well, what we will know before September 23 is the DCC, the document containing the charges filed by the prosecution. Yeah. Whether they focus just on the crime of humanity against murder, or as many Filipino victims are hoping, whether it will be expanded to cover torture or arbitrary and unlawful detention. Yeah. But right now it looks like it will focus on murder.
So there's really no telling. I guess going back to the first time the former president showed up, March 11, again, as I mentioned a while ago, we were a little surprised that the next time we were going to see him was 6 months later.
Yes.
During the confirmation of charges, again, we're not sure if the pretrial judges would decide on it on the fourth day, would say, we will make render a decision on September so-and-so or October. That is the only time we will actually know.
That is correct.
Okay.
And in fact, on your surprise that it takes 6 months, 6 month gap in seeing the former president. In fact, I was actually surprised that during the what we call the initial hearing, he appeared only on video link by TV, because normally they appear in person. In the court. Yeah. It's the first time the court will see the person of the accused, and I understand that it was upon request by the defense, in consideration of the health of the former president. Okay. So I don't know if they will do the same thing for the confirmation of charges, but that is 4 days, and. I imagine the former president will appear in person.
Judge,
in the court.
Will we be able to watch the proceedings from beginning to end?
Oh yes, they are televised, and that is the court makes full arrangements for that, including the access to the interpreters. Okay. Because if you notice from the pretrial, from the first hearing, some judges addressed him in French.
Right.
So we have the option to hear both the original and the English translation. I also for the witnesses, Pinky, I think the court has recruited interpreters for Tagalog and Cebuano, and I think a few other languages. So the court is quite particular that when the witness speaks their truth in the language in which they are most comfortable, it will be translated simultaneously for the judges.
I have a minute left, but I need to ask two more questions. In terms of jurisdiction, what is the likelihood that the ICC pretrial chamber will decide on the issue of jurisdiction prior to the confirmation of charges come September 23?
Okay. I imagine they will prefer to settle it after the confirmation of charges. The scope of the confirmation hearings is actually to confirm the charges. So it's, strictly speaking, not about jurisdiction. So if in fact, as I've said earlier, maybe that's one purpose of the latest filing, to have a preliminary ruling on jurisdiction. But I imagine they would like to deal with all these matters altogether.
And the interim release?
Likewise. Because some of the grounds for interim release, there are three possible grounds, to deny release. That is the risk of flight, and the second is the possibility of a threat and intimidation of victims and witnesses. Yeah. I think the second ground is one which is best explored with the evidence available during the confirmation hearings.
The resolutions, two resolutions filed in the Senate rather, one by Senator Alan Peter Cayetano, the second by Senator Bato, Senator Robin, and Senator Go, asking for a number one house arrest meaning in the Philippine Embassy in The Hague, and the other one is a house arrest in a residence in The Hague. If the Senate passes a resolution like that, what is that value to the ICC?
Nothing. I think, I mean, of course, it can always be conveyed to the court. I don't know who will convey that, who will transfer that information to the court, but whether it will carry any weight, I doubt it. The court will have to decide the question of interim release solely on the basis of the
three variables.
Yes, the variables provided under the Rome Statute.
Sorry, one last.
Yes.
In terms of his health,
yes.
His former wife was saying that he's skin and bones, butot balat, no?
Yeah.
We understand, of course, they say that in the ICC there's a medical facility enough to take care of the respondents there. But if you have somebody who may, due to isolation, there's physical and also there's mental issues that need to be addressed when you're alone. Does that also come into play when the judges decide on interim release?
Okay. Apart from the three grounds that we have discussed, the interim release can contain conditions. And I imagine if the three grounds, one of those three grounds anyway, is satisfied, then the humanitarian elements might be taken into account in the conditions. But I don't think they will go as far as what the senators are looking for, because that is something we do in the Philippines. There's some VIP jail somewhere. That is, if it happens, it will be the first time. Yes.
With regard to the senator's resolution, you mean?
Yes. Yeah. That's sort of a VIP arrangement for a prisoner.
Former ICC Judge Raul Pangalangan. Pleasure to have you. I hope to have you again, Judge.
I look forward to that, yes.
Thank you so much for your time. Pleasure.
My pleasure.
That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.